So we will get started here. For those watching on Zoom, you have the slide deck that I emailed to you. For those who are watching on Facebook, I posted the information in the comments or in the description of the event, so you can get the slide deck that Mallory will be going through today and get information on the CLE. Iowa MCLE is going through a transition with their technology today, so I haven't gotten that number yet, but I will send it out to everybody and distribute the Iowa CLE number here as quickly as possible. It will be approved for an hour of CLE credit in Iowa. It already has been in Nebraska. And tell your friends they get to watch this for 2 years for Nebraska CLE credit up to the end of 2022 for Iowa CLE credit for on demand. And we are delighted to continue this series with Dr. Mallory Henninger of Advent IP. Mallory, we've been talking about this for a while now. We finally got on the books, which is great. You love going to school, getting degrees, which has worked out very well for your practice area. And before we had other people on, we were talking about one of our previous ones, space law, that we did just the basic on space law, and your interest in that, and I appreciate you also watching other ones. We have an hour. We will take some questions at the end, so we'll leave some time at the end of this. You teach this as well at Creighton, so that you have that experience teaching people with about our level of knowledge of IP law. So that's great. But you also practice, which we're always excited to get the real world with the theory. So really do appreciate you taking the time to walk us through all the various facets. And I'll turn over to you. If there are any questions throughout, feel free to put them in the chat, and I'll ask them of Mallory as we go along. And also we'll have some time at the end for the questions and answers at the end. And anyone with any questions, you can certainly contact me, Dave Summers, and I am happy to facilitate any follow-up that you have and CLE credit for everybody. So with that, I'm going to turn over to Mallory.
Hello, everyone. I'm really excited to be presenting today on in the Just the Basics series on intellectual property. As Dave said, I am a patent attorney out at Advent, which is an Omaha-based IP boutique firm. And I also do teach at Creighton, although I actually teach food and drug law over there. So my background is in pharmacy, which has set me up well for patent practice. For patents, you have to have a science background. And I do a lot of drug patents, medical device patents, things like that for my clients. And then, of course, like I said, I teach food and drug law at Creighton. So that's kind of another area that intersects with both pharmacy and patents, which I'm happy if anybody has specific questions about food and drug law or kind of that area of law, I'm happy to answer questions about that as well, or answer email questions about that. But I'm going to go ahead and get started on this. So this is just a general kind of table of the discussion topics that we're going to talk about today. I'm not going to go into great detail about this slide. It's kind of for your future reference if you're looking back at this presentation to see what it covers. But the four main areas of law that we're going to talk about are patents, trademarks, copyrights, and trade secrets. Those are going to be your four key types of intellectual property. And for each of those different types of intellectual property, we'll talk about generally what it is, why you want to protect it, and then some kind of key tips for protecting that type of IP. We're going to start with patents. Patents are the most common type of intellectual property. They're the thing everybody thinks of when we talk about intellectual property. And in a nutshell, patents protect inventions. So they confer on the patent holder a limited monopoly to make, use, sell, import, produce the patented invention. And as you can see, Dave is modeling one of the inventions you can see in our slides here. These are some of the inventions we've featured on our firm's social media for Wacky Patent Wednesday, just to give you kind of some of the ideas of some of the interesting things that people are trying to patent. So definitely check out some of those. There are three key types of patents. A utility patent is the type of patent that most people think of when we talk about patents. And what a utility patent does is it protects processes, machines, manufactured articles, and then any compositions of matter and any useful improvements or modifications of those types of articles. So it's basically the common type of patent you think of. It protects the functionality of those items, the functionality of the invention, how it works, the method it works by, those types of things. And I try to give you an example of each type of patent as we go through here, and you can certainly take a look at the links to those patents later. But an example of a utility patent is this compression garment that you can see in this figure 2, basically a compression sock that goes on a patient's leg. So that's utility patents in a nutshell, protects inventions and how they function. A design patent protects how something looks. So it protects the ornamental features of that product or the overall appearance of that product. You can see an example of a design patent here on the slides, is this game board. It protects how that game board looks. So a design patent gives a different scope of protection than a utility patent. If you were to assert this design patent against a potential infringer, you could assert it against somebody that copied the way this product looks, but you can't stop somebody from making something that functions in a similar way. So this design patent is not going to be assertable against another game board if it looks different. So another soccer type simulation game board, if it functions differently. It's really limited to how that product looks. And so we'll often see clients getting a combination of utility patents and design patents to protect their inventions if both how the product functions is important and how the product looks is important. Design patents are also kind of a cool alternative to utility patents because they issue a lot faster and they're a lot less expensive to obtain. So they go through a less rigorous examination process because the patent examiner is focused just on whether or not they can find something that looks similar versus the overall functionality. So they're a little bit easier to get, and they can be a really good option for clients that need something quickly or a less expensive option. And the third type of patent is going to be the plant patent. And I'm not going to talk in depth about plant patents because I don't practice heavily in this area, and it's not a super common type of patent. But just so you know what they are, you can patent the discovery and asexual reproduction of distinct and new plant varieties. So for example, you can see the picture of the rose plant named Coleman. And the information you submit in a plant patent looks a little bit different than what you find in other types of patents. So you can see with utility and design patents, we have these kind of really cool line drawings that are provided in the patent. With a plant patent, you'll get a picture of the plant itself. And the one note I want to make on plant patents is that you have to be able to reproduce that plant in order to protect it. It has to be something that can be asexually reproduced. It's not you just go out and you're walking in a field and you find a new plant and you patent that. That's not patentable. You have to be able to reproduce that. When we talk about patents with clients, the number one thing we talk about is what are the benefits you get from obtaining a patent? Why do we want to get them? What's the value add that clients get by having these? And at the end of the day, you'll hear me talk a lot about with all types of intellectual property, as with most areas of law, whether or not the client needs it is really a business decision at the end of the day. So the client's going to be looking at what benefit are they getting versus kind of the expense that they're outlaying in order to acquire that intellectual property right. So why pursue patents? The first reason people pursue patents is because in general, it is the most valuable type of intellectual property right that you can get. Patents offer the broadest protection of all of the intellectual property rights, and in particular, utility patents offer a very broad scope of protection. As I mentioned, it can be used to stop other competitors from making, using, selling, importing, or essentially doing anything with your technology. So it gives very broad protection to the inventor for that invention. Patents can also be used to block out competitors. If your client is able to patent something, that is going to be a barrier from a competitor, for getting their own patents in that technology area, but also for, of course, practicing what is in your client's patent. So they can block out competitors in the marketplace. And oftentimes you'll hear patent attorneys talk about getting a web of patents or protecting a product with a variety of patents, be it different types of patents, like a combination of utility and design patents, or multiples of each of those. So oftentimes you'll find important technology protected by several utility patents, or a combination of several utility and several design patents. That creates this web of protection, or this fence of protection around the technology that makes it very difficult for competitors to enter. Because sophisticated competitors especially will know that in order to practice in that space, they're going to have to design around those patents, or be at risk for infringing those. And the more patents you have, and the better quality those patents are, the more difficult it becomes. Patents can also create uncertainty for competitors. Even just having a pending patent application can create uncertainty for competitors. Patent applications are published in most circumstances. We'll talk about publication in a second. But once those are published, just being patent pending and being able to label your product as patent pending when you start the patent process can create a great deal of uncertainty in the marketplace about what type of patent your client is going to be able to get on that product, what that patent is going to cover. And again, that can act as a barrier to prevent competitors from entering that space. Patents can also be used to create leverage against other patents. So in a lot of tech fields that are highly litigious, where clients are, suing each other frequently, patents can be asserted against each other. So it can kind of be a deal of, I'm not going to assert my patents against you if you don't assert your patents against me. And it can also be used for leverage in the sense that by having your own patent on your own technology, you can kind of use that as some evidence that you're not practicing somebody else's technology. If you get in an infringement scenario, it becomes easier for your client to say, no, I'm not doing what's in your patent, I'm just practicing my own patent. So they can be used as leverage against other patent holders. And then lastly, patents can be useful in obtaining funding or licensing opportunities. A patent is an asset, so it is just like intangible intellectual property assets are just like tangible assets. It can be sold, licensed, assigned, all of that. So oftentimes patents are something that investors are really interested in because they show that A, the business is serious about their technology, serious enough to pursue the patent process, and that B, they have some protection in place to prevent other competitors from coming in and doing the same thing. So it can often be really useful for obtaining funding, especially startup funding. A lot of investors really look at whether or not there are patents and how good those patents or patent applications are. There are also some risks to not patenting. So it's important not only to consider what are the benefits that your client is going to get by pursuing a patent, but also what harms they're at risk for if they don't pursue patents. One of the biggest harms that everybody talks about is, of course, if you're not patenting technologies, competitors or non-practicing entities can come in and patent around your technology or actually try to patent your technology. A non-practicing entity is essentially a patent troll or an entity that's just acquiring patents, but they're not actually using those patents. They're not actually making the technology or selling a product. They're just using those patents to assert or enforce against other companies. And so if you're not out there, if your clients aren't out there patenting their innovation, that leaves the door open for competitors to be doing that and patent around those technologies. Since the American Invent Act, the patent system in the US is a first to file system. So it's becoming increasingly difficult on the back end to try to prove that you were practicing something first or that you had the technology first if somebody else beats you to the patent office. It is doable in certain circumstances, like in the context of infringement, but it's something that's really difficult. So if your client's not patenting, they set themselves up for that risk of kind of having to prove or fight on the back end about whether or not they had the technology first. if your client's is not pursuing patents, they're also not creating prior art in their field. We'll talk just in a bit about what prior art is, but it's essentially publicly available information that is out there to prevent other competitors from getting patents in that technology field. So once there's publicly available information about an invention or an innovation, nobody else can get a patent on that technology once it's kind of been disclosed to the public or dedicated to the public. And if your client is not putting out information to the public that, or trying to obtain patents that would become prior art, then again, that opens the door for competitors to come in and try to patent that technology. I want to talk briefly about what is prior art, because prior art is really important to the patent process. Again, prior art is essentially any publicly available information that predates the filing of a patent application. So the way the patent process works is once you file a patent application, that application goes to the United States Patent and Trademark Office, the USPTO, and it is assigned to and reviewed by a patent examiner. That patent examiner is going to do a prior art search to see if they can find any existing publicly available information that happened before your patent application that would essentially make it impossible for your client to get a patent on that information. So what we really are concerned about with prior art is publicly available information that predates your filings. As you can see in this diagram here, we have our patent application filing date. If we have something that's published before that date, that can be prior art that a patent examiner can cite and bar your application from becoming a patent. And a lot of people kind of have the misconception that the Patent Office is only concerned about other patents or other patent applications, and that's really not the case. Anything that's available, anything that's publicly available essentially can become prior art. So the Patent Office will often cite technical articles, journal articles, things of that nature. I've seen them cite websites, other things they found online, sometimes social media things. They can really cite anything that's publicly available. And where it gets really interesting, especially with kind of like technical and journal articles, and one of the really kind of difficult areas you have to mitigate is with research institutions and other institutions that are heavy publishers, because it's kind of a conflicting goal. They want to publish on their innovation right away, and that can create some difficulties for the patent process. We'll talk a bit more about that in a second. Anything that happens after the date that you file your patent application, that's not prior art. So if a competitor comes along and files an application after you've already filed yours, that competitor application is not available to be cited as prior art against your patent application. So again, US has a first to file system. Once you've filed, anything that happens afterwards is not important to the prosecution of your patent application.
Can I ask a question on that, Mallory?
Sure.
So if I have an idea, is it good to just make a blog and put it up there, tweet it out, and then it's in the ether prior to potentially somebody else filing an application? Is it kind of the new way to protect something ahead of time?
Yeah, so that's kind of a multifaceted question. The short answer is you should always consider whether or not you want to file a patent on something before you publish on it, because in addition to being concerned about whether or not you're creating prior art that can be cited against competitors, you also have to be concerned about things that would bar you from obtaining a patent. So in the US, there's a 1-year period from when you have publicly disclosed or sold or offered to sell your technology in which you can file a patent application. So once that 1-year window has passed, you can't file a patent application any longer. You've basically dedicated that information to the public. So if you're not interested in obtaining patents and all you're concerned about is, I don't want somebody else to get a patent, then it's fine to publish and do those activities. If you're interested in obtaining patents, and particularly obtaining foreign patents, because some foreign countries don't even have a kind of grace period like that, then it's important to try to lock down your patent application filings first. So it's kind of a two-part question. Dana, does that answer that? Perfect.
Yeah, that was great. Let's get some really benevolent, smart people out there just helping us all get this stuff for free, right?
Right. And no, that's kind of become a thing right now. Like I'm sure you've all heard that like some major players like Elon Musk don't believe that patents, don't believe in patents, believe everything should be dedicated to the public. So it is kind of an interesting idea that's starting to arise, the level of which we should do that. There are some things which are not considered prior art, even if they happen before your patent application is filed. And again, this really focuses on that race to the patent office and being the first to file something. Prior art has to be public. If it's not something that's publicly available, the patent office is not going to find it and it's not going to be considered prior art. So things that happen internally, any invention, development notes, internal presentations, marketing presentations where clients are discussing like, these are the areas we want to move into or things of that nature, those are not going to be considered prior art. So secret inventions are not prior art. And so where this gets a little bit interesting is, say somebody invents a technology at this point on the timeline, and then a competitor comes along and independently invents something that's very similar. They file their application. That secret invention is not going to be prior art to that competitor's application. That competitor patent application will progress through the patent office and likely issue as a patent. Even if that secret invention, even if those inventors file an application afterwards, that after filed application, again, happened after, still not going to be prior art because we're not concerned with anything that happens after the point of filing. So that's where I say it's really important if your clients are interested in patents that they make sure that they are talking to their attorneys and determining when the best point to file is, because by not doing so, it is possible for competitors to come in and patent around or over that technology. And it gets really tricky on the back end to fight that. A couple of the other risks of taking a passive approach to innovation or a not filing patent approach is that you're essentially giving up one of the only types of legal monopolies that you can get for your technology. So again, a patent gives you a limited monopoly to, for a period of 20 years for utility patents to make, use, sell, import that technology. And so it's one of the only ways in our legal system that you can get a legal monopoly in your technology. By not filing patents on that, you're essentially giving up that right to have that legal monopoly. The second point, we'll talk about trade secrets towards the end of the presentation if we have time, but just a quick note on trade secrets. Trade secrets are another type of intellectual property. Trade secrets basically are exactly like they sound. It means that instead of filing applications or registering your intellectual property, you're holding it as a secret. And there are several useful reasons to have trade secrets, which we'll talk about again towards the end of the presentation. But the one thing I want you to note here is trade secrets do offer valuable protections, but the thing that they don't protect against is duplicated inventions. Trade secrets are only as good as they are maintained secret. They do not prevent somebody from finding out about your product and duplicating it, developing something similar or the same independently. They don't prevent against those things. So that kind of leads to the third point. Anything public facing, anything that's going out to the public. If your client is selling products to the public, if they're offering software or other technologies to the public, those are the technologies that are really at risk of copying because they can be acquired. They can be acquired by competitors. Competitors can copy them. They can use them for inspiration. And trade secret protection is not going to do anything to prevent that. So those public facing technologies are really where clients should be focusing their patent interests. There are a lot of good reasons to get patents, but there are also some trade-offs for acquiring patents. One, as I've mentioned, patents grant a limited monopoly. So they're limited in duration. For utility patents or our most common patents, that duration is 20 years from the date of filing. So one thing you have to consider with patents is the lifespan of the technology or the life cycle of the technology. Is that technology going to outlast the patent? And that's why you'll see a lot of things like recipes and things of that nature, those are often held as trade secrets because those don't expire as long as they're kept secret. And oftentimes those outlive that 20-year duration. So after this 20-year period, anybody can make, use, sell, practice that technology that's disclosed in that patent application. That's the trade-off that you have to give for getting that limited monopoly, is that you're disclosing that information to the public, and then the public can use it after that 20 years. Another kind of downside to patents is the lengthy application process that you have to go through to obtain a patent. We'll look at the timeline briefly in a second, but what I just want you to know for now is it's a long time period. It typically takes 5 or 6 years to obtain a patent. It's not a quick process. It's not a cheap process. And so the other piece you have to consider, again, with product lifecycle, is that technology something that's going to even be valuable at the end of that 6-year period? So especially in this high-tech world that we live in now, where software is everything and tech is just booming, that's a consideration, a very real consideration for a lot of clients is my tech product even going to be around in 6 years, or even valuable? Is it even valuable to obtain patent protection? The other key trade-off is the public disclosure requirement. So again, like I mentioned, in exchange for that limited monopoly in the technology, in order to obtain a patent, you have to disclose how to make and use that invention in your patent application, which becomes public when that patent is granted. So you're essentially telling the public how to practice your invention to the extent that somebody of reasonable or ordinary skill in that art would be able to practice that. So once your monopoly is up, anyone can practice that technology. So again, a patent is not a trade secret. Once you put something in a patent application, you can assume that at some point it's eventually going to become public in most scenarios, and it's no longer going to be something that can be held in secret. And you have to disclose that. That leads to a kind of a spin-off question of whether or not it's good to publish a patent application and kind of the trade-offs of doing that. When you file a patent application, you're able to choose whether or not you want that application to publish right away, or whether or not you want it to essentially be kept secret until a patent actually issues. So once a patent issues, it always publishes. And at that point, everything that happened during the prosecution or the obtaining of that patent publishes as well. But if you file that application with a non-publication request, the application is essentially kept secret until the patent actually issues. Otherwise, the application itself publishes at a date that's usually about 6 months after you file the application. There's some pros and cons to doing that. The pro is that if you file with a non-publication request, nothing ever becomes public if the patent doesn't issue. So if you abandon it for whatever reason, nothing negative ever goes in the record about why you abandoned that application, or what the patent office was asserting against you, what prior art they found that made it unable for you to get that patent. The trade-off for that is if you don't publish, your application does not become prior art that can be cited against other applications until you actually get that patent, or until it actually publishes down the road. So if the goal is, especially if your client's in a highly litigious area, and the goal is we want to be able to notify our competitors what we're doing, and we want this to block them from patenting in this area, and you're not going to want to file with a non-publication request. You're going to want that application to publish as quickly as possible so that it can be something that becomes cited against other competitor applications. There's also kind of a relationship to international patent protection as well. And this is often the kind of key turning point about what the decision of whether or not to publish an application. In order to file an international application or any foreign, a PCT application, which is essentially an international placeholder application, or a foreign application in another country, you have to have that application published. You can't keep it unpublished and be able to foreign file. So if your client is interested in foreign filing, they're going to have to publish that application. I wanted to talk briefly about the parts of a patent. I'm not going to go into a high level of detail. I just kind of wanted to show you what a patent looks like, so you have an idea as we go through the rest of the presentation. But there's three key parts to a patent: the specification, the drawings, and the claims. The specification is going to be the kind of wordy, long document that is really the detailed description of what the invention is. The drawings are going to correspond pretty heavily with both the claims and the specification. In the drawings, the applicant has to show any element that is going to eventually be part of the claims. So, and they have to include a reference character for that element. So each of these reference characters that you can see on this example figure 1 will correspond also to something in the specification where it details what that reference character is and provides kind of more analysis about what those pieces are. The claims then are what determines the metes and bounds of the invention. So you see the fence here, they're ultimately what determines what your fence of protection around your invention is. So if something is disclosed in the specification, not in the claims, it can't be used for infringement purposes. The claims are what a court is going to look at in determining whether or not someone is infringing your patent. And in order, we're not going to go into a great detail about litigation, patent litigation, because it's beyond the scope of what I do. But in a nutshell, in a patent infringement case, you would have to show that the potential infringer, the alleged infringer, is practicing each and every element of your claim. So each thing that's listed in this claim, in order to have infringement, the competitor, the alleged infringer, would have to be doing each and every one of those things in their technology. So this is really what gives the fence around your invention, is the claims. The specification, or the wordier part that we already talked about, that is used to interpret what is meant by the terms that are in the claims. So you'll see a lot of correspondence between the terms that are used in the claims and what is used in the specification. So the specification is a lot broader. It's used by courts to determine what the scope of those claims are and what the terms in the claims mean. But the claims are ultimately what is used for infringement purposes. When you go through the patent application process, as I already mentioned, the patent application is assigned to a patent examiner. That examiner has to look at several different legal standards to determine whether or not the application can be issued as a patent. We'll talk a little bit about each of those. The first is that the invention has to be something that is patent eligible. So we already talked a little bit about this briefly, that not everything is patent eligible. You can't just be walking in a field and find a plant and patent it. There are certain things that are not eligible. In general, as we noted earlier, patents can cover processes, machines, articles of manufacture, and compositions of matter. So essentially, they're things that you create, that you make, that you develop, that you innovate. What patents do not cover is abstract ideas, natural phenomenons, or laws of nature. So again, you can't go out and just find a new species of zebra and get a patent on that. It's really more directed towards things that you innovate or create. And you can't patent just an idea. You have to have enough that you actually have an invention. The other legal requirement is that you must sufficiently describe the invention in the application, and it must be described in a clear way. This is our section 112 requirements. Essentially what that means is that the language that's used in the claims has to correspond well with the language that's used in the specification, and that the technology has to be described in a sufficiently clear manner that one of ordinary skill would be able to practice that technology. Again, that's kind of our trade-off for getting the monopoly, is that we're giving to the public enough information they would be able to practice that invention after that 20-year period is over. There are also a couple of prior art considerations that the Patent Office is looking at when they're reviewing these applications. So again, we talked about prior art, anything that happened publicly available before you file your application. The examiner is going to look at that prior art to determine two things. One is your invention novel, or is it basically different than what's already out there? This is our section 102 requirement, and to determine novelty, the Patent Office tries to find a single prior art reference, so a single reference that discloses each and every element of your invention. So if the Patent Office can find something that already discloses your invention, it's going to make it difficult for you to get a patent over the novelty requirement. A lot of times this is the easier bar to clear, because oftentimes clients are pretty knowledgeable about whether or not somebody else is doing exactly the same thing they are. They usually wouldn't think they have an invention if they're aware of something that's identical to their product already in the marketplace. Where it gets a little interesting is the Patent Office can actually, for the purposes of 102, look to any field of invention. So they can find something in a different field of endeavor and use that as prior art against your client's application. So an example of this would be like if your client invented a closure for a water balloon that happened to look like a paperclip, the examiner could cite that paperclip against your client's application because it inherently, if it looks the same, it is inherently capable of keeping something closed or clipped shut, and they would find that there's nothing novel about that. The more interesting piece is non-obviousness, or our Section 103 requirement. And that's where we see the most of our action from the Patent Office. It's where we get most of our office actions from examiners is on 103. Under the non-obviousness requirement, your client's invention has to be something that is not an obvious difference or an obvious improvement over the prior art. And what this means in practicality is the Patent Office goes and searches for prior art references, and they take different prior art references that take pieces from one reference and pieces from another reference, combine them together, and use that to teach what your client is doing in their patent application. And as long as they have a rationale for why they're doing that, usually it's that the references are addressed to a similar problem or the same technical field as your client's invention, they can do that. They can kind of piece together an unlimited amount of references in order to try to get at your client's invention. And they can use, sometimes they use a lot of references. So we'll see sometimes, especially with things like recipes, where you have like a listing of ingredients or something, we'll see the Patent Office list 10 or 12 references, and they'll just go through and say, oh, here's one that teaches using corn in a recipe. Here's one that teaches eggs, and they'll just put them all together and use that to teach your client's invention. That's why certain areas have become really difficult to get patents in, and things like recipes or feed compositions, like livestock feed compositions, things like that are really, really difficult now because you see a lot of that. The examiners will just kind of piecemeal all of these different references together and use it to teach that invention. So that's really the more difficult bar, and where things get really interesting is in that 103 non-obviousness requirement. Other pieces that you have to know for the patent application process, you have to determine the inventorship, who invented the technology in the application. We'll just go through this briefly, but for the purposes of inventorship, it's going to be anybody that contributed to the conception of the claims. So the inventorship is really focused on the claims, and you can control inventorship by controlling what you put in the claims. So if for some reason you don't want somebody to be an inventor that was part of the innovation process, then you would not put anything that they contributed in those patent claims. You can still talk about it in the specification, but for the purposes of the claims, you would keep them out. And the reason inventorship is important is because it's important for the validity of the patent, but perhaps more importantly, it's important for ownership. The default rule of patent ownership is that patents generally issue to the inventors. So if you haven't made other arrangements for how the patent is going to be owned, the default rule is it will issue to all of the inventors as joint owners. And if anybody that's listening does anything with real estate or property, joint ownership is troublesome. It causes a lot of problems. It creates the same types of problems in the IP world as it does in the real property world, in that basically all of the joint owners have the ability to go out and license or sell their rights or do whatever, essentially whatever they want with their rights in the technology, which can be really troublesome. And it can also bar parties from doing what they want with their rights. So for example, none of those joint owners are going to be able to enter into any exclusive licenses or sell the entirety of the patent application or the patent because of the other joint owners. The joint owners can really create some problems. That's why it's important, as with other types of property, you want to make sure that that patent application or that patent is assigned to whoever you want the end owner to be. It's usually going to be a business. And I can't emphasize enough the importance of locking down those assignments early in the process, because you never know if somebody that started out with a company when you file the application is still going to be on good terms with that company 6 years down the road. So sometimes you can't find inventors, sometimes they leave on bad terms and make it really difficult to get the documents you need to assign that. So it's just really good to lock that down on the front end. This is the patent application process. I'm not going to go through this in any level of detail, but there's a couple of points I want you to note. One is that the patent application process always starts with the filing of a patent application. So this is the utility patent application process. The design looks a little bit different, but for a utility patent, it's always going to start with the filing of a utility patent or the filing of a provisional application. A provisional patent application is essentially a placeholder application. It's usually used when an inventor is still innovating on their technology, when the technology is maybe not quite finished, they're not quite prototype phase, they're still making changes. And it's used when they have enough information to say, I have an invention, but maybe not quite enough to have a full application. And when you file a provisional application, it sits at the patent office, and it acts as a placeholder to say, hey, I had this invention on this date. Now, a provisional application never issues as a patent. It always has to have something else happen to it. So in order to go through the rest of the patent process, you always have to convert that provisional application into a full utility patent application within 1 year of filing that provisional application. So it essentially buys clients a year from the date they conceived of their invention. It buys them a year during which they can kind of finish making improvements and things like that and decide if they want to go through the rest of the patent process. If you don't file that conversion, the provisional application dies. It goes abandoned. It never gets examined. And a lot of times you'll have clients come to you and say, I want to file a provisional patent because it's cheaper and it's less in depth, it's less detailed. There is no such thing as a provisional patent. The provisional application, it dies after that 1 year period unless it's converted into a full application. So it's really important that clients understand that to kind of mitigate their expectations going down the road. The other thing I want you to note is the length of the process. Again, patent prosecution is a long process. Once you file that full utility application, it's going to be 2 to 6 years minimum of prosecution time, or 2 to 6 years before you actually get a granted patent. And oftentimes this shows it'll be at least 6 to 18 months before you actually receive any type of office action or communication from the patent office. Really, in reality, with COVID and everything right now, that time looks really more like 2 years. It's really unusual right now to see something from the patent office sooner than 2 years, and sometimes it's longer than that before you even get a first communication. So it's a really long time. And again, that becomes important for product life cycle. If you have short-lived products, there may be no value in going through the patent process. And the other piece to remember with patents is that once they issue, so once you get a granted patent, there's maintenance fees for that patent. So at the 3.5, 7.5, and 11.5 years, the clients will have to pay maintenance fees to keep that patent alive. And those increase in size as they go through the process. So it's an expensive process, and those costs just kind of keep going. I wanted to touch really briefly on software patents because that's been a really hot area of concern lately with the kind of technological world that we live in. And there's been a lot of questions since the Alice Corp case about how patentable software is. I'm not going to go into detail about Alice Corp because a lot of you have probably heard about it. Any other IP people have probably sat through many, many CLEs on that alone. And if you haven't, it's really kind of beyond the scope of basics. But what I want you to know about software patents is they're difficult to get, but they are still being granted. And so it's important if your client is in the software space that they're working with a patent attorney that knows kind of the nuances about how to get software patents. But as you can see from this table, 60% in 2020, over 60% of all the US granted patents were somehow software related. So if people are telling you that you can't get patents on software, that's not true. It's just difficult, and there's some kind of nuances about how you do it. There are some practical issues with trying to obtain software patents, so I'm always really careful with clients about kind of walking through these difficulties on the front end, because this is definitely, anything software related is going to be a more difficult process with the patent office, and it's good clients to know that to kind of mitigate their expectations. Some of the issues you run into are patent on the pre-patent side, so the application and prosecution side, patent eligibility. The concern now, since the Alice case, is what happened in that decision is the courts essentially said that just taking an idea and implementing it on a computer does not make it patentable. So before that case, the belief was if you did something on a computer, it was automatically patentable because you were doing it with a computer and nobody had ever done it with a computer before, and that was somehow patentable. And the courts kind of came back and said, nope, just doing something that you could do by hand and putting it on a computer does not make something patentable. They still consider that an abstract idea. So that's a little bit of a barrier to overcome with software. And oftentimes you kind of have to combine software with hardware, or software with interesting features of a graphic user interface or something along those lines to get something patentable. Software life expectancy, again, this is another area where you really have to consider whether that software is even going to be valuable at the end of the patent process. And then on the post-enforcement side, or on the post-patent side, it can be really difficult to enforce software patents because it can be really difficult to determine whether or not a competitor product is actually using your software or doing the same thing that your software is doing. Software is not super easy to reverse engineer, especially complicated software. So it can become really difficult to tell. And I've actually been in a couple of really worked with some really interesting clients in this area where we've had a lot of difficulty determining whether or not software is infringing. Software updates are also a concern because when you file a patent application, you're filing something that won't issue for 6 years. It's hard to know what that software is going to look like in 6 years and whether or not the patent will adequately cover it. A good patent attorney is always going to try to be broad in how they cover an invention, but it's almost impossible on the front end to predict every different way that a client's software or innovation can go. So it's important to consider, will software updates be covered by that patent? At the end of the day, these are kind of overall patent considerations, and these are the things I always walk through with clients in determining whether or not they should obtain patent protection. The first thing is understanding the market. It's really important that you understand the market for the client's technology, understand where the company is headed in that market, what their goals are in the market, and just overall what that market looks like. Is this product kind of a standalone product? Are they going to make multiple iterations or different types of products related to it? And all of that kind of directs what the scope of protection is needed when you file a patent application. It's also good to, again, consider the competitors in the marketplace. Are they heavy patent filers? Are they highly litigious? Because especially in industries that are highly litigious, where you have a lot of heavy filing going on, if your client isn't filing, then they're kind of at a disadvantage. And so that's really where you want to be filing, is if your competitors are doing it, you often need to file applications to stay competitive. Budget's also very important. Patents are expensive. We tell clients to expect to spend anywhere from $25,000 to $35,000 over the life of a patent to file the application, acquire that patent, and then maintain that patent. It can go upwards quickly. It can be a lot higher than that too. And enforcement is a whole nother issue. As we all know, litigation is expensive. So it's always important to consider the budget, how much money the clients have to pursue patents, how many applications can they afford to pursue, and making sure they understand that it's an expensive process, so they're not disappointed when if they get in and then can't afford to proceed with the process. There are there is a pro bono process offered through the USPTO. So for clients that are low on funding, the USPTO has a process for matching them with attorneys that are doing pro bono patent work. So that's also an option. But bottom line, it's an expensive process. So it's not going to make sense, especially kind of for like low dollar inventions. It may not make sense to even pursue patents. Countries of interest are also important, mostly because foreign protection is also expensive. So it's important to consider on the front end where the client is going to be making the product, selling the product, or importing the product to. Those are all important considerations for helping the client kind of determine the overall budget and the overall countries that they want to protect the invention in. Probably the most important thing is understanding the client's patent goals. Why do they want to obtain a patent, and kind of what the benefits that they're looking to achieve. And there's a lot of different reasons clients can pursue patent protection. Some clients want to enforce. They know their competitors are doing something similar. They want to enforce right away. Some clients just want to create a barrier to entry. They want to make a web of patents so it's confusing to competitors that are trying to enter the marketplace. Some want to do defensive publications, which is essentially kind of what we were talking about earlier, getting your technology out there, publishing something just so competitors know that you are doing this technology. And oftentimes for things that clients think aren't really patentable, so like maybe just a minor change in technology or a minor improvement over existing technology, clients will file on that anyway, just to create that defensive publication and to prevent somebody else from trying to get a patent in that space. Basically do it so that they can keep practicing what they're doing, and so competitors don't try to get patents there. It's also important to understand your client's business areas. What are their core business areas versus their supplemental areas? If a client is trying to decide where to spend their patent resources, and a lot of times you'll get clients that have like many inventions and they're trying to mitigate where to spend their money, protecting their core business areas is often a good way to go, because oftentimes by protecting the core areas, you also can then protect the supplemental areas if you create a good enough barrier entry in the marketplace. The revenue generation and exit strategy is also really important. It's good to determine how is the technology going to be monetized, and what, probably most importantly, what is the client's end goal? Are they planning to actually market that product? Are they planning to license or sell that product? What are they going to do with it? Do they want to just license and sell the IP itself? Because that'll often dictate the patent strategy. So for example, if the client just wants to sell the IP, you're going to want to have a more rigorous patent portfolio, because that's essentially going to be the only asset that the client is going to be offering. And then again, the life cycle of the technology. Is the technology something that's going to is the patent prosecution process going to exceed the life of the technology, or is the technology going to exceed the life of the patent term? In both of those scenarios, patents are probably not a great choice. And then you also have to always keep in mind the nature of the technology. Are we talking about something that can be patentable or patented? Is it patent eligible subject matter? And then of course, is the technology something that's public facing? Because again, things that are going out to the public are more likely to be copied or used for inspiration. So that's really where your clients need to focus their energies. At the end of the day, to steal Nebraska's marketing slogan, patents, honestly, it's not for everyone. Of course, I'm a patent attorney. I love to sell patent services to people, but it's always, as with any other area of law, it's important to consider what the client actually needs and what they can afford and what makes sense given the technology they have. So it's always important to keep those considerations in mind, because again, you're going to have the best relationship with your clients if you can mitigate their expectations, help them find the right IP products for them, rather than getting them into a process that maybe doesn't make sense for them or that they can't afford. So now we'll talk about some of the other areas of IP law, and these parts will be a little bit shorter. We'll go through these a lot more quickly. The meat is really in patents, but I want to touch on other types of law that are available. So trademarks is probably the second most common type of IP protection. I probably do 50% of my practice, at least in trademarks. I can't emphasize the importance of trademarks enough. Even if your clients also have patents, they really protect two different things. Trademarks protect the client's brand. And whereas every client doesn't need a patent, I firmly believe almost every business needs a trademark. They should be protecting their brand. And it's a fairly inexpensive thing they can do to protect their brand. What is a trademark? A trademark is a word, name, symbol, or device which is used in trade to indicate the source of goods or services and to distinguish those goods and services for others. So what I want you to remember, it's a source indicator. It tells where that product or that service originated from. What can be trademarked? The traditional things that everybody thinks of when they think of trademarks are words, logos, pictures, symbols, letters, those kinds of things. And that's certainly the most common types of trademarks we see. We do a lot of trademarks for logos. We do a lot of trademarks of brand names. And those are the things we commonly recommend that clients protect. But there are also some non-traditional things that can be really useful for clients. So for example, you can trademark colors, so like paint colors. You can just trademark distinctive paint colors. You can trademark distinctive sounds. So the way a motorcycle exhaust sounds, a particular car exhaust, those kinds of things, that can be trademarked. You can trademark scents, unique scents. So this yarn here has a particular scent. That can be trademarked if it acts as a source identifier. And then product appearance and trade dress. So product appearance and trade dress is going to be anything related to the shape of the product itself or its packaging, or sometimes even like the look or appearance of a restaurant, things of that nature. It's generally the overall appearance of the product. So for example, the peep, the shape of the peep is actually trademarked. There are certain things that can't be trademarked. You can't trademark generic words. So you can't trademark the word apple for an apple. You can also lose your trademark if your term becomes generic. So an example of that is cellophane. Cellophane used to be a trademark term for plastic wrap. It has since been canceled because now everybody calls plastic wrap, or a lot of people call plastic wrap cellophane. So you can lose your trademark. That's why you'll see companies that have words that are at risk of becoming generic. They'll send a lot of cease and desist letters and they'll try to rigorously enforce that trademark so that it doesn't become generic. Kleenex is a really good example of that. They're really rigorous about sending out cease and desist letters so that Kleenex doesn't become generic, even though it kind of maybe already is starting to.
And I'll throw out there the Velcro wrap by their or by their trademark attorneys is great. Anybody who wants to Google search on YouTube, Velcro patent wrap. Or Velcro trademark wrap. It's very good. It's very good.
You also cannot trademark simple shapes, so simple geometric shapes. You can't trademark just the shape of a star or just a circle or a heart. And you can trademark those shapes if you add something distinctive to it. So if it has a distinctive color, if it's stylized in a distinctive way, if you add distinct wording to it, then it becomes protectable. But ultimately, simple shapes are kind of like generic terms by themselves. They don't really indicate the source of a product. You can't trademark functional aspects of a product, and this really relates to trade dress or the appearance of a product. So anything that's functional or anything that's important to how that product works, the utility of that product, you can't trademark. So an example of is this motor here. There was originally an allowed trademark application on this motor, claiming the layout of the parts, and that was involved in a cancellation proceeding, which ultimately resulted in the Trademark Trial and Appeals Board considering that to be functional. In other words, these parts were not arranged for any particular source identifying or appearance aspects. They were arranged this way because that's how they had to be put together in order for the engine to work properly. So if your product looks a certain way because it's necessary for how that product functions, that's not something that's going to act as a source identifier, and it's going to be considered functional and not. And then government insignia. You can't trademark government logos, government symbols, or government insignia. How do you obtain trademark protection? There's two main ways. The most common way that we usually talk about, so that attorneys like to talk about, is registration, because that's what we do. That's a service we sell. And I strongly believe that everybody needs a registered trademark. When you register a trademark, you obtain that protection by filing a trademark application with the USPTO. That application can be based on actual use of the mark in commerce, or an intention, a bona fide intention of your client to use that mark in commerce. The caveat here, it has to be used in interstate commerce because, as we all know from our con law classes, Congress can only regulate interstate trade. So we're talking about interstate commerce here. But that's a pretty low bar to satisfy for the trademark office. Essentially now anything that's offered on a website or things of that nature is going to be considered to be used in interstate commerce, regardless of whether or not it's actually sold to clients out of state. You can also obtain trademark rights by common law use, which is just using the mark. And so your clients get certain protection just by going out and using their mark on their products in commerce. And they're going to use this TM symbol with those marks. And I always tell clients to use that TM symbol even if they've started the registration process to basically notify the public that they do consider what they're using to be a trademark. Once they go through the registration process, they get to use this cool circle R mark. And we'll talk about why that's good in a second. A couple of quick notes on trademark registration. Term of registration is 10 years. It's renewable. There's also a renewal at between the 5th and the 6th year date where you have to file a declaration of use and basically show that you're still using the mark. But beyond that, 10-year terms can be renewed every 10 years. In order to obtain a full trademark registration, you do have to provide evidence of use to the USPTO, or proof of use. So you have to show them a specimen of how you're using the mark. And you have to provide one specimen for each class of goods and services that you're trying to register in. Not every product, but each class of product. I know I said earlier that you can file an application based on an intent to use, and what happens with those is they can get allowed by the trademark office, but then they kind of just sit in allowed state until you provide this proof of use. So you don't actually get a full registration until you've proved use. Use is really important for the trademark office. Trademark rights are all based on use. The last thing I wanted to know on registration is that the use of the trademark will be audited throughout the process. So the Trademark Office instituted an audit process a couple of years ago where they audit marks at the renewal period to make sure the clients are actually using those marks for the goods and services that they have stated in the application. Because failure to use your mark for your goods and services can cause you to lose rights in that mark. And what that audit process looks like is they'll send you a request to provide specimens for particular types of goods or services that are in that application or in that registration. If your client is unable to do so, the Trademark Office will then ask your client to provide specimens for every other good and service that is listed in that application. And then if they're still unable to provide specimens, the Trademark Office will cancel anything that your client cannot provide specimens for, and they will charge them a fee for doing it. So the strategy several years ago used to be that companies would list every good and service under the sun in their trademark applications. This audit process is trying to get back at that and trying to get companies to hone in on what they're actually using their marks on. So that's one piece to keep in mind when you're doing these applications. I'll go through quickly the benefits of why to register. So a lot of you are probably thinking, if you have common law rights, why do we need to register trademarks? There's a lot of really good benefits. The first is that that registration creates a nationwide constructive use and right of priority in that mark. So once you register, it is presumed that the client is using that mark nationwide and they have a priority in that mark across the nation. It also serves as constructive notice. It serves as notice for anyone in the nation that you have rights in that mark. So that relates to some of these other pieces, like it prevents other junior users from acquiring rights in that mark because it is constructive notice that that mark is taken. It also creates some good legal presumptions in court. So if you are in an infringement proceeding, it creates some legal presumptions about that you are the exclusive owner of that mark and that the mark is valid. So you don't have to prove those things in court. They become a rebuttable presumption. A U.S. trademark can also be used as a basis for foreign registrations or foreign trademarks, which can allow your client to circumvent some aspects of the foreign trademark registration process, such as proving use in other countries and things of that nature. It allows your clients to use the Circle R, which can be a deterrent to competitors by indicating that that mark is registered. It allows them to enforce in federal courts. That's probably the most important piece. In order to sue someone for trademark infringement, in federal court, you have to have a federal registration. And federal courts have exclusive jurisdiction over trademark matters. So really, in order to enforce, your client has to have a federal registration. And there's also some benefits about the ports of entry that you can, if the mark is registered, goods bearing registered marks can be excluded at the ports or at the border from entry into the United States. A quick note on the overlap of trade dress and design patent protection. We talked about earlier that design patents protect the appearance of an article. Trade dress also protects the appearance of an article. They do so in different ways. For design patents, you do not have to link that appearance to any type of source identification, but you also only get a limited patent term. Trademarks can be used indefinitely. They can be renewed indefinitely, but they have to be tied to the product, the shape of the product or the appearance of the product being used as a source identifier. So some examples of trade dress are of products that are covered by both trade dress and design patent are the Coca-Cola bottle. You can also see the Apple iPhone is covered by a couple of design patents and a trademark. There's a lot of questions right now because trademarks and graphic user interfaces are really new about how good that protection actually is. And in fact, Samsung and Apple were involved in a court case over the iPhone. where the trademark or the court actually found their trade dress to be functional and invalid. So in other words, the court said the only reason that these icons were arranged the way they are is because that's necessary for the use of the phone. So right now, the thoughts are that these types of trade dress protection or these registrations in GUIs are going to offer pretty limited protection, but you still see a lot of interest in filing there. And that's mainly because a lot of times when design patents get ready to expire, or other utility patents get ready to expire, then companies show a lot of interest in getting trademark protection because it's one thing that they can maintain indefinitely. We're running short on time. I'm gonna touch really briefly on copyrights and trade dress. These are a little less in-depth areas. Again, like I said, trademarks and patents is really what we focus on, but copyrights can also be useful for some clients. Copyrights protect creative works, they could protect works of authorship, and any work of authorship that's fixed in a tangible medium. So when your client writes something on paper, when they put something on a computer, that becomes a fixed tangible medium of expression that is eligible for copyright protection. These can be literary works, dramatic works, musical works, artistic works, and these are some of the examples of things that we talk about when we talk about copyright protection. The common things that everybody usually knows about are poetry, novels, books, songs, photographs, artwork. Those are pretty common plays, common creative works. Some things that are a little bit different that not everybody knows about are you can copyright computer software. You can copyright the code behind that software. And so we see since software patents are difficult to obtain, we see a lot of interest in getting copyrights from code. You can also copyright websites, the look of websites, and perhaps most interesting, you can actually copyright architecture or the way a building looks. And I've actually been involved in cases about architecture, so that does come up, which is kind of an interesting thing that you can copyright the look of a building. What you can't copyright is underlying facts, ideas, systems, methods, or listings of ingredients. And the caveat here is copyrights really protect the way things are expressed or the mode of expression, not the underlying thing itself. So for example, when you talk about like an architectural copyright will protect the unique way a building looks. So if you have a really cool like glass geometric shaped building, it will protect the overall look of that building. It doesn't protect things like having a door or having 8 by 12 rooms or general things that are common to all buildings. It doesn't protect that those underlying functional pieces. The same can be said with like games. There's a lot of game copyrights. A lot of companies copyright the look of game boards or the rules for games. And the caveat of that is your copyrights will prevent somebody else from making a game that looks exactly like yours or has rules that are expressed exactly the same way yours are, but it doesn't stop people from making a game that is played the same way. You can't stop somebody from, having a game with the same type of rules. It only protects how you're expressing those rules of those elements. So it protects unique expression. Copyrights are easy to obtain. They're like trademarks. You have common law rights in them, and you get copyright protection just by putting something in a tangible medium. So as soon as your client puts something on the internet, that's in a fixed medium, it's copyrighted. Like with trademarks, federal registration does provide additional benefits. It's a much easier process than trademark or patent registration. That's why I have my easy button here, because it's really the easiest type of registration to go through. I'm not going to go into detail about the why register. What I want you to know is the points are pretty much very similar to trademark protection. You get the same kind of presumption of validity in federal court. You have to have a federal copyright to enforce in federal court. They offer the same benefits of constructive notice and the same kind of benefits as to the ability to exclude infringing products at the border. So it's very similar to trademarks, the types of benefits you're going to get from registering. The one piece that's a little bit different is eligibility for statutory damages. In copyright cases, if you have registered your copyright before infringement occurs, your client is eligible to get statutory damages or a per instance damage award for each instance of infringement, as well as attorney's fees. And so if there's any litigators out there, statutory damages are pretty good. Especially in copyright cases, damages can be really difficult to prove, and it can be really difficult to prove the amount of the damages or calculate the amount of the damages. So that's really one of the key pieces for registering. And I'm pretty much out of time. I'll give you the 1-minute speech on trade secrets. Trade secrets are exactly like they sound. They are anything that's held in secret that's not generally known to the public. What makes them different from just the regular secret you might have with your friend or your family is that they have to confer some type of economic benefit. So they have to have an economic value in order to be considered a trade secret. And they have to be subject to reasonable efforts to maintain that secrecy. So you have to be doing something to protect it. So you have to have reasonable security measures in place, reasonable contract, NDAs, those types of things in place in order to show that you're maintaining that secret. I always say trade secrets are like caterpillars. Only 3 things can happen to trade secrets. They're like the easiest type of intellectual property. The 3 things that can happen to them are they can continue to live like a caterpillar, so they live as a trade secret forever. The secret is maintained. Everybody is happy. There's a lot of good examples of companies that are doing this. And we'll talk about examples in a sec, but for example, like the recipe for Coca-Cola, that's been held as a trade secret for decades, and it's been maintained. The secrecy has been maintained. The second thing that can happen is the caterpillar dies. So the secret is not maintained. You don't have a good NDA in place. Your employee goes out and tells his friend who works at a competitor company. They start doing the same thing. The secret's gone. So the trade secret dies and it just doesn't exist anymore. So in order to keep that going, in order to maintain that protection and be able to enforce it, you have to maintain that secrecy. And then the last thing is the caterpillar morphs into a beautiful butterfly. So the trade secret becomes a beautiful patent and it lives as a patent for the rest of its life, for the 20-year lifespan, and it becomes protected that way. But remember, because you've had to disclose that to the public, anything you put in those patent applications is no longer a trade secret. These are some examples of things that are held as trade secrets. A lot of recipes, as we talked about, recipes are really difficult to get other types of IP protection on. So you see a lot of recipes held as a trade secret. That also relates to the life cycle of the products. A lot of these things would have outlived any type of patent protection. So KFC recipe, Coca-Cola recipe, Dr. Pepper, the Big Mac special sauce, Krispy Kreme, all of those are held as trade secrets. You also see a lot of things that are like algorithms, because again, those are things that are often considered abstract ideas by the patent office, so you're not going to get any protection on those. So like the Google search algorithm or the criteria for the New York Times bestseller list, we all kind of wonder how those things work, but they're secret. Benefits of holding trade secrets: they become effective immediately. You don't have to do anything to register them. There's no cost to registering or maintaining them. So they're essentially free, except for enforcement, but they're free to have. They have unlimited duration, so unlike patents, they don't expire. You can hold it forever as a trade secret as long as the secrecy is maintained. You don't ever have to disclose anything to the public. In fact, you shouldn't be disclosing anything to the public if you want to maintain the secrecy. And probably most importantly, they are available when other types of patent protection are not. Again, a lot of things that are eligible for patent protection, like recipes and algorithms, those are what are going to be held as trade. And then just a couple of tips that we'll end on for maintaining that trade secret protection. Again, you have to keep it secret and show that you're taking reasonable efforts to maintain the secrecy in order to enforce for misappropriation of trade secrets. So some of the ways that you can do that are making sure that documents are labeled appropriately, label things as confidential that include trade secret information. Make sure, and I'll say a lot, educate your employees. Clients need to be educating their employees. Their employees know what things are trade secrets. If clients are working with trade secrets, or if employees are working with trade secrets, they need to know the policies in place about those. Have NDAs or non-disclosure agreements in place with key employees and with third-party vendors. And make sure your employees know which vendors you have NDAs in place with, so they're not just kind of talking at random. This comes up a lot with like research institutions and things like that, because a lot of times the people that are going out and trying to make like research agreements, they're not experts on law. They don't always know like when they need to enter into agreements. It's really important to educate people about not disclosing too much until you have proper agreements in place. And then watch out for time limits in contracts. Most of you probably know that usually NDAs or other agreements have a limited duration, often like 3 or 5 years. Make sure that the trademark or the trade secret protection is indefinite. because that's perfectly legally acceptable and it's what you should be doing. So watch out for for kind of artificial time limits that don't account for trade secrets properly. Have good cyber and physical security. You have to show that you're doing reasonable efforts to maintain and protect trade secrets. Cybersecurity has gotten a lot of interest over the last decade because we're all concerned about technology right now. So of course, things like multi-factor authentication, all of that good stuff, those are all good for maintaining trade secrets, but also be concerned about physical security. Make sure that you have proper access controls on doors, windows, security cameras, things of those nature. So don't forget those pieces. And then watch what is being included in patent applications. That's one of the places that patent attorneys add real benefit, is by helping clients determine how much they need to disclose, and helping clients determine what aspects can remain as trade secrets. And then helping clients know that when something is about to publish that does include trade secret information, that they're prepared for that and kind of the ramifications. And again, educating employees so that employees understand how to protect trade secrets, because the number one source of data breaches, of leaks, is always employees, and it's oftentimes not malicious. It's often a misunderstanding of policy or just carelessness. So educating employees is really key. That's all I have for today. I'm sorry for running over a little bit. If anybody has any questions, I'm happy to answer them now, and I'm also happy to answer any questions you might have or that our on-demand people have via email, so feel free to reach out.
Thank you so much, Mallory. Really appreciate it a lot. A big area to cover, right? I mean, there's so much there. I have one quick question, and it's on copyright. You talked about the attorney's fees being offered in those cases. There's a pretty big, a growing group of copyright trolls out there, right? That's kind of the new thing. Yeah.
Yep.
Because you have all these content creators and people just finding something online and then posting it and everything like that. And oh, here comes somebody who has, the copyright claim to that. And maybe they just got it because people are posting it, but it's not actually, there's no real benefit going on besides it's a troll situation. They're just trying to get the attorney's fees out of it, right? So always be careful on the copyright.
Yep, that's entirely true. Copyright trolls are a huge issue right now, and that's exactly what they do. Is they basically look for people. Oftentimes they assert claims that are not even legitimate against people that are, there are certain situations with copyrights where you can have fair use of copyrights. So if you're not getting an economic benefit off of the use, like if you're just resharing something on your Facebook page or something, you're not getting any benefit from it. But a lot of times these copyright trolls will send kind of their nasty grams out to people anyway. And it can be a really difficult deal for clients because, once they get one of those, there's either the fear that they're going to get sued or they have to get an attorney involved to kind of fight that. It can be an expensive thing for them to mitigate. And we see that happening a lot right now. So it's kind of an unfortunate situation with copyright.
And yeah, I mean, it's the ugly side of IP law, right? Not all of the actors, not all of the attorneys are on the good, for sure. I don't have any other questions on Facebook. I don't see any other in the chat. Like I said in the chat, we will get the extra 15 minutes of CLE credit for everybody. So they get 75 minutes instead of 60 for the price of 60. I really appreciate your time on this, Mallory. And I think it's ongoing. And I think I've said before, and many people have said, IP law is the background of the US economy in many ways and our place in the world. So I'm glad that we get a better understanding through you of what's out there, and look forward to seeing where it goes from here. So thank you.
Thank you for having me. Thanks, everyone.
All right. Have a good day.